Good morning to all. Today we will discuss one case law from the Arbitration and Conciliation Act. The main question in this case law decided by the Honorable High Court of Delhi is that in case the company is strike off during the arbitral proceedings and the award passed after that is allowed or not. The High Court has said that even though the company is strike off, the Companies Act does not bar that company from receiving its claims or realizing its claims. Therefore, the arbitral award cannot be set aside. This is the order passed by the Honorable Delhi High Court. Now, coming into the case law. The case is between Exotic Buildcon Private Limited versus Medas Biotech Private Limited. This order is passed by the Delhi High Court. Observation is that striking off of company's name by ROC post commencement of arbitration not a ground to set aside arbitral award or award. Exotic Buildcon Private Limited is the appellant in this matter who is filed an appeal before the Honorable High Court. And they are also the appellants before the Commercial Court, which is a lower court, wherein they have filed an appeal before that Commercial Court against the order passed by the arbitrator. This is the case. Exotic Buildcon Private Limited appellant filed an application under Section 34 of Arbitration and Conciliation Act in the Commercial Court, challenging an arbitral award in favor of Mrs. Medas Biotech Private Limited, the respondent. The appellant challenged the arbitral award primarily on two aspects. Firstly, it argued that the respondent's name has been struck off from the Registrar of Companies in 2017 under Section 248, subsection 5 of the Companies Act, when the arbitral proceedings were ongoing. And come down. Arbitral award. And second, it argued that there was a cancellation error, calculation error in the awarded amount. This Commercial Court dismissed the appellant contention regarding the striking off of the respondent's name from the Registrar of Companies. The Commercial Court referred to Section 250 of the Companies Act, which specified that cancellation of company's incorporation does not affect the realization of amounts due to the company or discharge of its obligation. Consequently, the Commercial Court held that the proceedings for realizing the amounts due to the respondent would remain unaffected. Agreed by the decision of Commercial Court, the appellant filed an appeal before the Honorable Delhi High Court. The appellant contended that it was the respondent's responsibility to undertake steps for the restoration of its name and on the Registrar of Companies before proceeding with the arbitral proceedings. Decision of the High Court. When acknowledging the necessity for strike of company to take steps for restoration of its name on the Registrar of Companies to pursue its claims, Honorable High Court held that setting aside the arbitral award on this ground wasn't unjustified. The High Court noted that the parties were referred to, scroll down, arbitration before the striking off of the companies, before striking off of the respondent's name. Therefore, the arbitration is started before striking of the respondent's name, with the statement of claims filed even earlier in 2015. Moreover, the High Court observed that in 2015, a substantial number of companies have struck off for non-compliance with the Companies Act. The High Court referred to the decision in Value Advisory Services versus ZSTE Corporation, wherein it rejected objections to the enforcement of an arbitral award based on company's name being struck off of the Registrar of Companies post commencement of arbitral proceedings. The bench held that the arbitral award cannot be set aside merely because the respondent's name, company's name was struck off from the Registrar of Companies post commencement of arbitral proceedings. It upheld the principle that cancellation of company's incorporation does not affect the realization of amounts due to the company or discharge of the obligations. Come down. Scroll down. Yes. Considering these facts, the Honorable High Court concluded that interference with the arbitral award based on respondent's name being struck off wasn't warranted at this stage, consequently dismissed the appeal. So, what we can learn from this is, even though the company is strike off, it does not bar that company from realizing its dues or it does not save the company from paying its dues or its obligations. Though even though the company strike off, there is a liability by the company and its director has to pay. In case the company, there is a due for the company, then the company has all the rights to receive its dues. Okay. So this is the order passed by the Honorable High Court. Any doubt?
No, sir, I don't think anybody has any doubt.
Okay. Thank you.
Yes, sir. Thank you, sir.
Thank you so much, sir.